Good afternoon, ladies and gentlemen, and a very warm welcome to you to this very important session titled Building Legal Synergies Between India and the US to Promote Economic Growth. We discussed in great measure yesterday how important and symbiotic in so many ways is the relationship between our two great nations. We also discussed that the United States continued through the pandemic to be India's largest trading partner and also the source of the largest FDI into India. But business and commerce apart, our interests are so intertwined in so many ways. It becomes so important for us to look at where the synergies are and where they're missing in terms of the legal systems of our respective countries, and especially what comfort or lack of it US companies have when they do business in India, what reforms the Indian government has undertaken, which of course has been commendable over the last few years, but still what is remaining to be done, where are the gaps, where are the wrinkles, and how can we make it better for US companies doing business in India? And as I'm speaking more from a one-way perspective right now, because while Indian companies have started going global and many Indian corporations now are not just doing business in India, but also acquiring companies in the US, the fact remains that inbound into India is far greater today than outbound from India to the US, and which is why the theme of this session is focusing on Indian laws, how we can fix them, what have been the achievements, and as I said before, where are the gaps which we can work on. Without further ado, let me introduce our very distinguished speakers for today. We have Anita Agarwal, who is Chief Counsel for AT&T in India. And in this role, Anita provides legal and transactional support for AT&T's multiple business and strategic interests in India. In her position as General Counsel for AT&T's Indian operations, Anita advises business leaders and decision makers in her company in undertaking prudent risk assessment and mitigation, of course, consistent with AT&T's commercial goals and objectives. Anita also handles and supervises policy and regulatory matters, complex litigation, as well as the company's Indian CSR initiatives. Anita's past experience includes working in the chambers of a reputed senior counsel in the Supreme Court and also a top-tier Indian law firm, where she was active in the infrastructure and the financial transaction space. Anita has also been a visiting faculty to Bucharest Law College, Hamburg in Germany. In terms of her educational qualifications, she holds a bachelor's degree in law from Delhi University and a master's degree from Columbia Law School, New York City. Very warm welcome to you, Anita, and thank you for joining this session. From one of my favorite cities in the world, we have Rahul Gupta, who's a partner in the Capital Markets Group of the leading international law firm White & Case. Rahul has more than 20 years of experience advising on complex, cross-border, India-related transactions and specializes in securities and corporate law with a special focus on capital market transactions. Rahul is dual qualified in England and Wales and India from National Law School, Bangalore. Rahul Gupta regularly advises underwriters and issuers on various equity and debt capital market offerings pursuant to Rule 144A and Regulation S, including IPOs, qualified institutional placements, high yield bond and convertible bond issues, MTN programs, as well as tender offer and share buybacks. Rahul has a formidable reputation in the Indian financing market. Amongst various other feathers in his cap, he is recognized as a leading lawyer for Singapore capital market transactions by Chambers Asia Pacific 2021 and Chambers Global 2021, as well as ranked as a leading individual for Singapore capital markets by Asia Pacific Legal 500 and also IFLR 1000. If that is not enough, Rahul is included in the International A-List 2020 by India Business Law Journal and was recognized as one of Singapore's 70 most influential lawyers aged 40 and under by Singapore Business Review 2016. Rahul, delighted to have you. Very warm welcome. And if I may say in lighter vein, you remind me of how I was aged 40 and below.
Thanks a lot, Rohit.
Welcome. So with this, we'll jump straight into our working session. Question number one, Nita, for you, we'll commence with you since you have so much experience representing the world's largest telecommunications company and guiding decision makers and business leaders in India. Question for you is, how difficult or easy do you think it is for a US multinational like yours to negotiate the Indian legal market and the legal system? So over to you.
Thank you, Rohit. First, I'll say that the change in technology with telecommunications has become communications.
If I can request you to kindly speak a little louder, sorry. Yeah.
Okay, technology across sectors, whether entertainment or telecom, it's all merging and converging. So it's a communications company, no longer really only a telecom company. So with that, I'll say that in the post-COVID world, with the changing geopolitical realities, the scope for strategic partnership between India and several like-minded countries, including in particular US, is immense and growing. And we can see high-level delegations visiting India and our Prime Minister scheduled to go there. So there is a lot of scope of political strategic partnership, and with that, of course, trade and business and investment and cross-border flows. Now, what is the India? India is fast evolving and changing and transitioning, as you have noted yourself. Laws are changing, investment climate. How hard or difficult? Well, India is not I wouldn't say it is a cakewalk that you just do. I see from my colleagues, say in Australia or New Zealand, maybe, I don't know, the business deals, they will always say, no problem, just okay. India, you cannot mark the tick boxes like that, just like that. However, so there are issues. There are issues like, it takes time, there's a lack of clarity, there is some inefficiency here and there, interoperability is not there. At times there are, over-regulation, so there are issues. Having said that, I think some bit is also a matter of perception. People have this old notion of what India was, that it is difficult, and that perception needs to be changed. And secondly, it depends on how you navigate. I mean, if I don't ride a car and I just sit down on the wheel, I'll find it, I may be the best driver in US. But if I ask you to drive in India with cattle and cars and scooters and everything on the same road, you may find it difficult to navigate. But on the other hand, I may be very good in India, but I will find it difficult to go on fast lane, with no traffic stops. So you need to know how to navigate. If you do, then I think, and you know how to take advantage of all that India has, the potential and possibilities, then it is not very difficult market. and also the legal thing that you're referring to. And in addition, I have to point out that, the trade-off in terms of the size and attractiveness of the market, the young educated population, one country with the largest young population, size. That for an international investor or business is a very attractive proposition. So that kind of, as a trade-off, less than if it was a smaller country, didn't have this kind of attractive market, it would have been a hurdle. But they are willing, for those who are willing to gird the lock and plunge into it, it's an interesting and exciting market. I don't think it's a very difficult market if you know how to move around and make the most.
Thank you, Anita. Moving on to you, Rahul, since you're such a celebrated personality in the capital markets sphere, I thought I would ask you that when Indian companies try and raise capital from US investors and especially sophisticated US corporations, what do you think are the challenges that you see in this scenario?
Thanks, Rohit, for the very glowing introduction to begin with. I think you did me too much of a good deed by saying everything you said, but thank you for that. But let's go over the question that you asked. And I think you have to view this access or market access of India with different hats. If you look at it from a private equity perspective, India and Indian companies attract every manner and kind of investment from sophisticated US investors. I think the only types of investors that you don't get access to are, like Nita put it, people who don't want to get into the driver's seat in India. People who are happy accessing what they can sitting in the United States, and they're not looking at emerging market risk. But if you are looking at emerging market risk and you are looking to diversify your portfolio as a US investor, then all of the quality names are prevalent and available in India. And they have, through trial, error, legal advice, lack of legal advice, tested the waters and figured out how to access India as a market. So I think on the FDI, private equity, MNC side from US investors, India's become a known playbook for most sophisticated people. I think when it comes to capital markets and trading and looking at accessing some of these players who are large pools of capital that exist only in the US, I'm pretty certain there's a huge category of investors that just don't look at India. And that market access for those investors is restricted because of various conditions that they have to jump through to get into the Indian equity capital markets. You can only come in if you're an FPI, if you're an institution. And that registration requirement raises all kinds of questions. And while SEBI and the government of India has been looking at the FPI registration and easing the process to come through, it's just viewed as a regulatory hassle that people don't want to do. So there are people who will just not look at India as a market because of that one reason. The other structure that works there is participatory notes and market access through a derivative product. And again, the amount of regulatory scrutiny and heat on that product has generated over the years. There are quality investors that will just not go down that route because of the challenges and risks involved. So there are challenges in market access for Indian companies. Having said that, we have seen in the last 2 years Indian unicorns come out and access capital and do transactions in varying degrees and sizes and complexities, and it doesn't seem to be that much of an impediment. But having said that, there is a lot more that can be done. There's a lot more that can be done to give market access to people in the United States for the Indian markets.
Thank you, Rahul. Moving on to question number 2, and Nita, I'll pose this to you. And now I'll speak from a positive and a favorable perspective. We all know that India has done a lot, not just in terms of opening up the economy and sectors and reforms, but also various policy initiatives taken by the government, new and positive reforms in certain sectors such as insurance and defense, rationalization of Indian laws, and I'm also looking at something which we speak about all the time, which is more transparency and reduced compliances. So based on your experience and all the time that you've spent in your leadership role in AT&T, helping and guiding business, are there any 1, 2, or 3 major reforms or initiatives that you would like to single out and commend the Indian government for?
Thank you. So I don't think it's 1, 2, or 3. It's looking at the whole perspective of the government. When your prime minister has the capacity to say, I will be like the CEO, and things like, transparency or inclusive growth, sustainable and impact investment, and clean and green, and innovation. These are not just boardroom buzzwords, but also being heard in corridors of power in government offices. Then it is showing a shift in mindset. It is showing a sensitivity and awareness of the need of the hour. And it is showing that the government, the bureaucracy, the system is moving towards change. And it is happening very fast. So that is it all starts with the mindset. As I said, the perception, yes, we had issues and problems once upon a time, but we are getting out of it. And the speed and escape velocity is high, and the buzzword and the mindsets are changing. So that is one very important thing in government, and the openness about discussion, talking. Now we are interacting with government through, we have this periodic inspection of telecom under the licenses. Recently we did through a video conference, which was unthinkable. This was in Mumbai. Routinely people have to travel from all over, someone from Hyderabad, because team people are spaced out, someone from Delhi. And now it was possible through a presentation to respond and answer and show, didn't only save time, but it shows how forward thinking and government people are willing to extend their hand equally to meet the situation. So there's a lot of shift and change taking place in thinking and working. And one thing which brought it out very amply and shows where we can go is how quickly and nimbly the government responded to the need for work from home. As you know, India is an IT hub, and a lot of work centers and back office work is happening. Suddenly, and this was both in lockdown 1 and in lockdown 2. Suddenly, when you ask, and the systems, the technology, even in the corporations was set up, because all the security systems, the connectivity was to working from an office environment. Working from home was not thinkable on a regular basis. That once in a while, yes, it's a flexible work environment, but no one ever thought even from a corporate perspective. But suddenly and in these work centers, there's a what is called other service provider, OSP regime, where if you work from home, you have to have bank guarantees and IP addresses and this, that, lot of compliance. It's very tedious and difficult to implement. But suddenly, government was able to adjust, made all kinds of relaxation, did away with these cumbersome requirements, so much so that now they have made the change permanent. With the result, it has become work from anywhere at any time. You don't only have to work from home, you can work in a hotel or you can work from anywhere in the country. And a lot of compliance requirements, a lot of inspections, a lot of filings have been done away with. Now, this looks like a small change, but it's the ease of doing business and working, and in terms of generating employment. Because now people can be taken from tier 2 cities, tier 3 cities. It doesn't matter where you're working from. So the pool of people available and the jobs going to the home has increased both for the employer and for the employed, and therefore for the government. A lot of good has been generated by this. So the movement of the government and positive policy change made very quickly to respond to the need of our ensure there was business continuity, ensure that people were also not inconvenienced or exposed, balancing the COVID safety security norm with the business continuity norm. That was really commendable. That's one thing which I have like to say, that shows where, how and where and what we can do, and what the government can, how it is ready and willing to facilitate and meet the challenges.
Thank you very much, Anita, for sharing your positive thoughts and insights. I do have some questions and some concerns as a practicing lawyer, which I will speak about later when it's my turn to do so. So moving on to you, Rahul, the second question for you is, and this again is something we're trying to draw upon your experience and your expertise as a capital markets expert. When you look at India on one side and US on the other, there are differential risk perceptions and disclosure standards in capital market transactions. The US and other markets follow very stringent norms for international listings. As counsel, what has been your experience, and how do you bridge the difference in expectation between Indian issuers on one hand and international investors on the other?
Thanks, Rohit. So I think the one thing to keep in mind is that disclosure standards and valuation and risk perceptions across markets are very common themes. So I would go so far as saying it's wrong to assume that the Indian disclosure standards are at a lower level than an international standard or a US standard or any other standard. I think SEBI has done a very good job in keeping the standard pretty high and adjusting to market realities from time to time. The one area where I think that potentially there is work that SEBI could look at is in bringing in more of a concept of materiality into its rules and regulations, giving practitioners some ability to take a view on certain aspects of disclosure, which you're able to do in certain other markets. I think SEBI is very prescriptive on certain aspects, that you just have to produce certain information, even though it's not material to investors. So keeping that thought aside, I think the two key themes on any transaction that you have to keep in mind is valuation. At the end of the day, as an advisor, what I'm doing is trying to get the company a prospectus that when investors read, it gets them the best valuation for their shares. And at the same time, I'm trying to balance that valuation perspective with a risk perception, that you don't want the company making a misstatement or omitting to put in some information into its prospectus and therefore taking on risk when it gets investors to invest in their company. So keeping these two themes in mind, it's very easy to then bridge the gap between what SEBI requires in its prospectus standards and what international investors are used to seeing. Over time and historically, I think the biggest areas of where a disconnect has taken place and continues to exist, and where we as practitioners in capital markets face issues on practically every transaction, is on the accounting standards. And if I were to delve into a little bit of detail on some of these things, the two areas where we see constant challenges are unique scenarios where issuers, for example, have done material acquisitions. And the SEBI standard for disclosure prescribes preparation of what are called pro forma financial statements showing the impact of the acquisitions in only limited circumstances. Whereas in the international standard, there is a requirement for preparation of these pro forma financial information in multiple situations. And as long as the company believes that that information is material, you are allowed to bring in that information into your prospectus. However, we as practitioners constantly have a fight with the auditors on this point, saying that if the SEBI guidelines don't require it, we're not allowed to prepare this information and disclose it in the book. And it becomes such a constant hassle that you have to try and find ways and means of getting this information into the prospectus, not in the form that you would typically get into the prospectus in an international document. So that's one area. The second area is SEBI prescribes a great amount of detail on financial information requirements, but leaves certain gaps for interpretation, which again become a cause of challenge between the auditors and the lawyers and the company. Simple example is, for example, if you're producing stub period financial information for September or June or December in any prospectus, the SEBI guidelines are silent on the requirement to prepare corresponding prior period disclosure. So if you're preparing September 21, SEBI is silent whether you need to prepare September 20. And in the US, we would pretty much, as a given, prepare the prior period numbers. We would have a good comparison between the two sets. But in India, the auditors take the view that it's possible to not do away with that prior period. So these are, I think, small issues, but material issues, and they ultimately go to the 2 points on valuation on risk, because an investor looking at the most recent financials wants to be able to compare them to how it was last year to decide and see how the growth trajectory of the company has been, whether everything we've said in the prospectus about how the business is doing and how our strengths and strategy are actually playing out in the numbers. So the lack of that information plays into valuation. And similarly, the lack of that information plays into risk, that you have not disclosed what would in other markets be considered material information. And I think we get to that position by threat, by convincing, by pretty much every argument in the book to try and bridge that gap. But I think if there were clear guidance from SEBI on some of these issues, you would be able to then not have these debates on every transaction. I think in some areas, SEBI is better than international norms. I think SEBI has prescribed such detailed, interesting requirements on the corporate governance side, on the board composition side, and you actually see other markets now catching up with SEBI on some of those aspects. So I think it's a very curious and interesting area of practice for us, where we actually see SEBI ahead of the game in some respects and behind the game in some, and you have to marry them and balance the two to get to the right conclusion for the client.
Thank you very much, Rahul, for your very valuable and practical insights. Turning to you, Anita, and this is the last question for you, and then a common question for Rahul as well, once you have responded. So Anita, thus far, you've spoken very positively and favorably. And I think the current dispensation and Prime Minister Modi would be delighted that you are such a great ambassador for them. But may I ask you, there must be some pain points, some wrinkles which, in your opinion, need to be ironed out, some practical business, legal issues, difficulties, irritants that AT&T faces or has faced in the past, in your opinion. Would you like to speak a little about that, and also how you think the government could fix it?
Thank you. Before I just want to add one to earlier, before we get to the pain points. The Vodafone judgment, we cannot overlook that. That was a very bold move. It was a pain point with business. Practically all of the MNCs which had sold their businesses at that point of time. And suddenly, after years of litigation through the IRS equivalent tax department in India, multiple layers, and the court system, and getting a win, and then having a retrospective tax slapping huge billions of dollars amount when there was no money, nothing had been provisioned for, because advanced tax rulings had said that you don't need to pay. And asked to pay where there is no money, it was a very difficult situation, very negative sentiment. To overturn it in one legislative amendment required bravo, and it has sent a very positive message. So that is something very commendable, and a lot of companies have been affected and benefited from that. And I'm not saying just tax, the tax three-letter word in every corporate law class, corporate finance class, you are told is the most important consideration. So it's very relevant and shows the mindset of what can happen and possible in this country. And it's not, I would say it is way now people are looking at the government and the government's attitude, whichever government, they cannot go back on these kind of things. There's a change taking place. That's my main, emphasis point. Now, coming to the pain points, well, a lot has been done, but a lot still needs to be perhaps to be done. Increasing efficiency in the system, more transparency and openness and certainty in law, and less flip-flop. There should be, like in business, you say quote to cash or speed to market. You have to move fast because opportunities come and go away. So the system has to be made relatively more nimble to allow money to come in with ease, flow, the cheap quote unquote of money, how it comes and goes and moves. That has to be, so there has to be less time taken in setting up a company, less time in getting it operationalized, the regulations, the requirements, all that just now that Rahul was pointing out from a capital financing in every other sphere, that has to be loosened so that, in bankruptcy proceedings, in resolution, enforcement of contracts and resolution of disputes, years on litigation and fighting it out. Corporate world doesn't have that kind of time. All that time that goes means money and labor and manpower. So the easier it is made, the quicker, the faster, the smoother, the more the attractiveness of the market, the more will the capital come and more will employment and all the other accelerator effects will take place. Another is, the integration and in the application of law. For instance, IT today is horizontal, with everything becoming digital. The way we live, work, play, everything is digital. And so it's not just IT. And therefore, the laws also have to be modified accordingly. You cannot have regulation from IT department saying one thing, telecom department saying another thing, broadcasting department saying a third thing, the regulator TRAI saying the fourth thing. The orchestra has to have symphony and coordination to bring music and not noise. And the smoother it is, the better it is for the investors. That music brings money. So
Sure.
the interoperability and better harmonization between the various departments in the laws, and some of it are generic. Privacy law, again, it's not a matter of just the individual's right. The laws have to be enforced by various departments. Now, if every government sector comes up with their own privacy requirements, then complying with them for even an Indian business, let alone an MNC, becomes very difficult.
Right.
Which is not to say that you should not follow the requirements. You should, but you have to have certain generic across the board which are applicable, and then specific sector wherever, whatever.
Sure.
So this is something which government needs to be mindful about. To
Thank
make
you.
Sure that it is
Thank you, Nita. Very well spoken. And may I say that I echo your sentiments, especially on the need for coordination and compatibility and harmonization between what different government agencies speak and do sometimes. So Rahul, very quickly over to you, and I'll request you to confine your response to 2 minutes. You spoke about some challenges in terms of accounting standards, as well as gaps in interpretation. Is there anything else you'd like to add in terms of peeve points and recommendations on how they could be fixed?
Sure. I'll be very quick. I have just 2 points. I think I love pretty much everything about the current bull run in India as a capital markets partner. But the biggest pain point, I think, is that we should be able to take these Indian companies and list on the NASDAQ or NYSE directly. We shouldn't have to resort to renew type structures and find convoluted ways and means of taking quality Indian companies to US capital markets. So that would be my pain point number one. Whether it's ADR listings or direct listings, we really need to find a way to do this. The time has come. We have multiple unicorns in India that need this capital, and they would flourish whether they were listed in Bombay or they were listed in New York. And to deny them that, or to tell them to have to find some structure to do it different from direct listings, I think is not right. I think that really needs to be addressed. And the second is a theme closer home and closer to my heart, which is liberalization of the Indian legal market. I'd love to be sitting in Mumbai or Delhi and doing this work that I'm doing from Mumbai or Delhi rather than Singapore. I've been an exile for 13 years, and I think it's time to come back. So those are the 2 points from me. Rohit, thank you so much for inviting me.
Well, thank you, Rahul. And the first point you made it resonates very deeply with me. And I also believe that if we change our laws and regulations, reform them such that our very, very reputed and successful and accomplished Indian companies are able to access overseas capital markets easily, it's great for the Indian economy because you have so much cash and so much more capital for Indian companies and the Indian economy to play with. So I completely endorse that comment, and let's hope that the relevant stakeholders from the government end are listening to you carefully and do something in this direction. I will move on to our very important guest from the US Embassy, Matt Ignery, and very warm welcome to you, Matt. Before I request you to speak, let me share your exalted credentials with our delegates. So Matt Ignery is the Economic Growth Unit Chief at the US Embassy in India. I was not aware, I must apologize, Matt, I wasn't aware that there was such an exalted title in the US Embassy. So delighted to have you with us. Matt is also responsible for Indo-Pacific strategy, investment, infrastructure, women's economic empowerment, and financial and macroeconomic issues. Matt previously worked on trade and investment issues in Southeast Asia for over 10 years, serving as Deputy Economic Counselor in Kuala Lumpur, Director for Singapore, Vietnam, and ASEAN. Matt's experience also includes working as the Philippines Economic Desk Officer and Senior Asia Trade Officer for the State Department's Economic Bureau, responsible for US-Korea FTA, the Asia-Pacific Economic Cooperation, and Trans-Pacific Partnership. Before joining the State Department, Matt was an attorney at the Washington, D.C. firm, Howry & Simon, specializing in foreign antitrust, mergers and acquisitions, and intellectual property litigation. Matt Ignery received his BA from Sarah Lawrence College and a JD and MA in International Relations from Boston University, and is a member of the New York and Washington, D.C. bars. Once again, a very warm welcome to you, Matt, and over to you for your address.
Great. Thanks, and happy to be here. No one knows better that time is money than lawyers who are forced to parse out their lives in 6-minute increments. So I'll try to keep this tight, but Rahul will definitely like where I end up with this. So first off, I just wanted to agree with you. You know, the economic part of our bilateral relationship is often kind of described as being the laggard compared with the strategic or the counterterrorism or the security relationship. But the progress is actually pretty astounding when you think about it, of where we were 20 years ago versus over $140 billion in annual bilateral trade. So you mentioned the U.S. is India's largest trade partner, we're India's biggest export market, and U.S. companies are India's biggest source of foreign direct investment, though a lot of that is routed through Singapore for tax purposes. Likewise, we've been hardened by the era of reform over the last 7 years, but also noted that there's been a renewed momentum and vigor since the end of the national lockdown last year. I'm going to get to some of the reforms I think more directly affect the legal practice. But as folks mentioned, one reform that will probably eliminate some legal work in a good way is last month's repeal of retroactive taxation, which I agree sends a tremendous signal to the investment community that this is indeed a new India. And the assurances by the government over the years that they opposed this and would never do it were all good and great, but we as lawyers, or even lapsed lawyers like myself, we all like to have things clearly in writing and in immutable rules of statutes and regulations. Sort of where we go from here on the broad side in terms of investment, there's obviously a lot of tremendous foreign direct investment in India, a lot of interest in the Indian market. I think the new frontier, frankly, is how do we transform India into a Indo-Pacific supply chain hub and node, and increase investment for manufacturing for export. And that requires a much higher level of legal certainty, because you're talking about 20-year 20-year investments, either in infrastructure, the power sector, or manufacturing plants. A lot of reforms, but I think to me the big next step that needs to be taken is really regulatory transparency and certainty. And this is kind of what we hear consistently from our companies, and this can apply for last minute tariff increases that happen while goods are still on the ocean. This can apply to changes in tax rates that completely scramble the numbers for an investor or investment. And it can involve highly technical compliance issues. And I would say, insisting on public consultation and public comments and reasonable time periods for those comments and reasonable time periods for implementation, I think that's the next big frontier. And I think that's an area where we, US business, Indian business, and the Indian legal community can really help this government in understanding that as important as the number or complexity or level of restrictiveness of regulations are, the actual process of creating those rules and imbuing that with as much transparency and feedback as possible is really key. Moving over to the legal sector, I think we've seen an underappreciated revolution in commercial law the last 7 years. When you think of the big banner reforms of the Modi era and what this does for the legal sector in terms of assisting companies with compliance, it's really monumental. We've had foreign investment liberalization, where we've gone from a centralized review system to basically the automatic route for almost all sectors, and working individually with line ministries. On the one hand, that's a more liberal and open system. On the other hand, for legal counsel, it can be more challenging and complicated, because now you have different players and different rules, and as folks have said, sometimes those rules can be at odds with one another. Another, I'd say, underappreciated outside of India reform is the Bankruptcy or Insolvency Act, which is really seminal, and I think everyone needs to be paying more attention to ensuring its continued success. GST, obviously, just a taxpayer bill of rights that was passed last year, largely based on US statutes. The changes to the labor law last year following the lockdown, that particularly the raised caps for employment to allow for greater growth of medium-sized businesses. The liberalization of the insurance market. I just mentioned the retroactive tax repeal last month. And then finally, without commenting on the substance of the reforms themselves, the agricultural law reforms obviously are going to create a completely different landscape, including for foreign investors particularly those looking to get into areas like cold chain or transport and logistics. And you combine that with existing, and in some cases maturing legal regimes such as India's competition law, securities law, intellectual property law, and you realize even when these new rules liberalize or simplify the Indian legal regime, it's still creating a need for legal counsel to foreign investors to help on how to navigate these new systems. So yes, it's a new India, but just as legal counsel remains necessary in a place like the United States, or even someplace like Singapore, the role of the legal system and the legal counsel and the legal community here as guides for foreign investors or Indian companies looking to make the next leap, or those small Indian firms that want to become medium-sized firms. I think we're actually on the verge of an explosion of the need for legal work. And quickly, I wanted to give some praise for the setting up the National Company Law Tribunal. Not only in terms of providing for faster resolution of cases, but also as a specialized court where the judges hearing these cases have a far greater expertise in commercial and corporate law matters. And of course, reducing the multiplicity of litigation efforts when you had the Company Law Board and the Board for Industrial and Financial Reconstruction, and this kind of multiple litigation system. Turning back to sort of the Indo-Pacific. So on the one hand, I talked about sort of the next stage for large-scale investment. I think from a regional perspective for the legal community, we're already seeing a lot of in India and the Indo-Pacific legal process outsourcing, which where were you all 20 years ago when I was an associate buried in some warehouse digging through litigation documents? But this opens up areas for Indian lawyers with expertise in arbitration, alternative dispute resolution, competition law, environmental law, trade, and so on and so on. And obviously, the widespread use of English as a working and professional language in India is a huge advantage. And to get to kind of the point that Rahul was making, I think I agree in terms of the need to further open up the legal market. There's been some initiatives allowing foreign lawyers to visit India, provide counsel on foreign law, and then get out. But frankly, it's a much longer flight for someone to come into India than it is for a DC lawyer to travel to Virginia, where it can sometimes feel so much restrictive as well. And I think it gets to this fundamental issue, which is we need to stop seeing each other, the US legal community and the Indian legal community, they need to stop seeing each other as competitors and really focus as more on partnership. The potential synergies and ability to expand existing synergies is gigantic. Even if the Indian legal market opens up completely, like what is in all of our US free trade agreements, there'll still be an extensive need for Indian local counsel. In fact, I would argue there's probably be a bigger need. More players, more investors, more firms, it's just going to be a bigger pie. Likewise, as you mentioned, Indian investment in the United States is growing. The need for local US counsel for Indian companies in the United States is growing. Those Indian firms that already have relationships with US firms that can facilitate and help those clients are going to have an edge just because they have those networks. When I
echo your sentiments, Matt. And in fact, the Society of Indian Law Firms, of which I'm one of the founding members and the Honorary Secretary General, we are also not opposing the entry of foreign law firms into India anymore, which was the case about half a decade ago. So
that's great to hear. I know former Ambassador Vermeer, really, as a lawyer, really held this issue very dear to himself and did a lot of work on it. And I understand it takes a while for these attitudes to evolve, but I think when you look at where the trade and investment relationship is, I think the writing is fairly clearly on the wall. And I just want to finish up with two anecdotes on this point. One is from my time at Howry. Howry was basically an antitrust and intellectual property firm, and its overseas offices were largely concentrated in Europe. I worked on international antitrust compliance pretty much everywhere else but Europe, and in Japan and Mexico, even Kazakhstan once. We had an extensive network of outside counsel that we regularly turn to, which leads into my other anecdote, which is having worked on administrating and implementing the Singapore U.S. Free Trade Agreement. When we opened the legal market in Singapore, of course, every place that opens these markets, everyone has these concerns that they're going to get flooded in, and firms like White & Case or Howard, if he was still around, are going to come in and swamp everybody with armies of lawyers, and it really didn't happen. There was a handful of U.S. firms that opened up. The rising tide lifted all boats. Like I said, all these synergies and relationships developed, and
I apologize, Matt. My profuse apologies. I received reminder number 5 from the secretary that we overshot by 6 minutes. And as I said, I found all your comments very interesting. And thank you very much, Anita Agarwal, Rahul Gupta, Matt Ignereni. I look forward to meeting with you in person, Matt, when I return to Dubai. And many thanks to each of you for making this session so engaging and so interesting.
Thanks for having me.
Thank you.
Thank you.